at some point, when you read the decision to charge guidelines that were passed long by my senior, Mr. Nurdin Haji, while he was in office, and of course in accordance with the Office of the Director of Public Prosecutions Act and the Constitution, the DPP, even sometimes when we have a preponderance of evidence, might be slow at taking action due to probably public interest in a matter. Sometimes the DPP, while exercising his authority to charge or cause the charging of an individual of any criminal offense, sometimes even with the lack of enough or sufficient evidence, he might be slow to make the decision to charge because of the questions about public interest and the proper administration of justice. So that we must underscore, so that when we see any action or inaction from the office of the ODPP, we must be well informed of the background, of the rationale behind the ODPP refusing or declining or taking an action to either cause the charging of an individual or declining to do so. So that must clarify the legal regime that we find ourselves in that gives the ODPP the power to either press charges or decline to press charges. But on the question of the decision to press charges, well, on a number of occasions when the office of the ODPP is invited to charge or authorize the charging of an individual, many a times we have seen, because the ODPP is charged with the responsibility of guiding investigations in all the investigating agencies, be it the Directorate of Criminal Investigations, be it the KWS, be it the EACC and other government agencies. So with the authority bestowed on the Office of the Director of Public Prosecutions to charge, sometimes people who are given the responsibility of investigating, and that is the reason why you see so many cases being dismissed in court, is because people who are given the obligation of conducting investigations, many a times they are either negligent on certain aspects of the criminal investigations, or they come up with the investigations that are not complete. For that reason, there has been occasions where the Director of Public Prosecutions has, in exercise of his mandate, directed investigative agencies, particularly the EACC, to go and cover up certain areas so that when the case is taken before the court of law, the case is watertight. But many a times we see the EACC making nonsense or very serious things. The EACC claiming that someone like probably His Excellency, the Honorable Natembeya, has been arrested for proliferating public resources to the tune of billions of shillings. Only for the charge, when it is presented before the competent court of law, for the members of the public to be informed that Mr. Natembeya, the Honorable George Natembeya, has only been accused of participating in acts that have been deemed to be corruption-related offenses to the tune of about 1.2 or 1.5 million shillings. So it is important that we stop the games about the fight against corruption. All of us want to deal decisively with corruption in this country, but there must be goodwill, especially from investigators within the Republic of Kenya. And I speak so specifically with reference to the office of the EACC. The Ethics and Anti-Corruption Commission comes to me as the weak link towards the fight against corruption. Many a times we know that when the areas have been recommended for them to cover up and investigate, but they end up withholding the file and taking no further action in the file. So we must be very genuine in the fight against corruption. If the EACC is quite clear with its mandate, if it is so determined to taking stern action against people who are engaging in anti-corruption offenses, well, they must be faithful to the people, they must conduct thorough investigations. They should not take, the kind of investigations we are seeing is that the EACC goes, conducts an arrest, then after conducting an arrest, that is the time they are surrendering the file to the office of the ODPP to give directions as to whether this person X or Y should be charged for that offense. Well, we know too well that the DPP is independent, and the DPP, for him to do what is right and just, because his decision is a decision that is ultimately meant to affect the lives of so many people who will be relying on this particular individual that is treated as a suspect to the offense. So, for us to assist the office of the ODPP to protecting lives, to ensuring the proper administration of justice, to ensuring that we protect the public interest, to ensuring that we do not allow the criminal justice system to be abused at the whim and caprice of people who've been given the mandate of investigations. It therefore means that the DPP must be given and accorded enough and sufficient time to peruse through the file, and any recommendations given by the office of the ODPP must be acted upon by the investigator. When we have a situation where the investigator turns sense on top of its head by deluding the members of the public, the unsuspecting members of the public, that the person that is not assisting in the fight against corruption is the office of the ODPP, while we know too well it is the office of the EACC that, number one, fails to make